Yes. Mr. Dingia will have to close it. Your wife, out of her own volition, has left you. And after decriminalization of this particular offense, we have the police has taken the statement in the is there in this CD and the pen drive. And once Mr. Sharma has produced it, we have no doubt about it. We don't want to play it and then see for ourselves because uh, the uh, the statement is sent by the senior superintendent of police, Kamrup, Amin Gaon. So once she has left, you have to take a recourse to the law. Statement of the police of your wife before the police is there. You have given. Okay. We'll record this because the address is there, and she has alleged that there was no smooth marital life was not there. We can't help it. That statement copies here. Alright. Thank you. ये कुछ ना कुछ तो ये It's a strange world. We can't do anything. Heard Mr. Alan Dihingia, learned counsel for the petitioner, who's also heard Mr. P. Sharma, an additional senior government advocate for the respondent. Next para. By filing this habeas corpus petition under Article 226 of the Constitution of India, the petitioner has expressed grievance that his wife, named in his FIR, filed on, lodged on 28/2025 before the Senior Superintendent of Police, CID, Assam, is reported to have been missing since 3/8/2025. It is projected that on the same day, information was provided to Rajbari police station, but the whereabouts of his wife could not be found. First of it is alleged in the said FIR that these two people are parents of the girl. That the parents of his wife had abducted his wife and that she along with that his wife along with one Vishnu Rabha don't say the name, you just say one particular person named in the FIR is also missing. Next para. The learned counsel for the petitioner has submitted that he suspects that the parents of his wife, in collusion with the person named in the FIR, have abducted his wife, and both of them have fled away. Full stop. Next para. Pursuant to order dated 25/9/2025, the learned senior government advocate has submitted that in the meantime, the concerned police officials have conducted an inquiry, and during inquiry, it is unearthed, and the investigation carried out so far shows that the wife of the petitioner had informed the family members that she was having some meeting and she was going far away, and since then she was untraceable, and subsequently on receipt of an FIR dated 13/8/2025 by the mother of the wife of the petitioner, Palasbari PS GD entry number 20 dated 13/8/2025 was registered, and the petitioner has also submitted a complaint before the Senior Superintendent of Police, Kamrup, on 15/9/2025, which led to registration of communication bearing memo number crime CRIME oblique Roman 4 dash PG capital oblique 2025 oblique 5799 dated 15/9/2025, by which the said FIR was sent to the officer in charge of Palasbari Police Station. Full stop. Next para. According to the communication dated 13/10/2025, issued by the Senior Superintendent of Police, Kamrup, Amingaon, addressed to the learned Additional Senior Government Advocate, copy of which is produced before the court, it has been stated that the wife of the petitioner, out of her own will, eloped with the person named in the FIR of the petitioner, and she was staying with him at a particular village in the district of Jorhat. And accordingly, the officer in charge of Jorhat Police Station, upon instructions, had recorded the statement of the wife of the petitioner, which was recorded and videographed. And according to the said communication by the Senior Superintendent of Police, Kamrup, the wife of the petitioner did not have a smooth marital life, and she had eloped with the person named in the FIR of the petitioner and is presently staying with him at Jorhat. First up. Resultantly, no element of kidnapping was found. And as per the statement of the wife of the petitioner, she wants to stay with the said person and not with the petitioner. Full stop. The statement of the wife of the petitioner, which was recorded under, which was videographed, has been produced before this court in form of a compact disc. Next para. As the statement which has been recorded in writing is available along with the as enclosure to the said letter dated 13/10/2025, the court is of the considered opinion that no point would be served to play the compact disc and to hear the same statement, which is already available in the written form. Full stop. At the request of the court, a copy of the said communication dated 13/10/2025, along with enclosures thereto, has been provided to the learned counsel for the petitioner. Full stop. Next para. Under the circumstances, as the alleged victim, as the wife of the petitioner, who is allegedly a victim of kidnapping, has been traced out and her whereabouts have been known, has been informed and her statement has already been recorded by the police in the concerned case diary, comma, the court is of the considered opinion that the purpose of this habeas corpus petition has been achieved with the tracking out of the wife of the petitioner. Full stop. Accordingly, without prejudice to the petitioner, to take such legal steps as he may be so advised, comma, this habeas corpus petition stands closed on satisfaction. Just before that, where we have said that he has produced this data, the same is made a part of the record. This will be a part of the record. So this
Supply item 14 with 15.
yes, you have any instructions?
My lord, the government is ready to deport them, my lord. But this honorable court has prohibited, there is a stay order in this case, my lord. There is a stay order passed by this honorable court not to deport my lord, the husband of the petition. So we cannot deport. 26(6), my lord, order. Otherwise, my lord, in fact, my lord, the factual position is that they were once sent back. They again came back, my lord. They were kept. Now they are kept in the my lord holding center at Kukurat.
This is something, my lord, which has been said for the first time. It was not told.
No, my lord, that is the factual position.
My lord. Secondly, my lord, if they have, my lord, completed the verification of
Yes. That is the present, my lord, situation. What I have, my lord, come to know. And now, my lord, the government is ready to deport them once again. But as there is a stay order, the government cannot deport me. Otherwise, government.
my submission be if the national verification, my lord, national verification has been done, my lord, let them produce the results. It's the, if there is, my lord, if they have, my lord, been able to verify, my lord, then things are different. Otherwise, my lord, where do they report? How they report? My lord? That's not the question. So let them produce, my lord, the national verification for whatever they have done. That will make things clear, my lord.
Yes. Yes. Both.
Otherwise, my submission is that detention is violation of the Supreme Court orders.
This is the heard the submissions of Mr. M. Dattar and counsel for the petitioner, as well as Mr. J. Pang, and standing counsel for the FT matters. FT and border matters. For Union of India, who's there?
J. Sharma. J. Sharma.
J.
J. Sharma. Miss J. Sharma.
Also Ms. J. Sharma, done at CGC, as well as Mr. P. Sharma, done an additional senior government advocate. for the respondent numbers 227. No, 225 and 7.
My lord,
225 and 7, you will be for 6.
for respondent number 4 in overtaken.
You will be for the
I will appear for my lord 2,
2 and 6.
6 and 7.
2, 6 and 7.
Yes.
Okay. Mr. J. Pai.
5, 6 and 7, my lord. Superintendent of police also. So
Okay.
only my senior friend will be appearing in respondent number 4, my lord. District Commissioner Sira. 4.
2 and 4.
Yes. Police I will appear, my lord.
Okay. Additional senior government advocate for 2 and 4. And for 3,
Yes.
5, 6 and 7, Mr. Pai. That's answer. List on 24/10/2025 for delivery of orders.
Item 2 with 3.
I had to.
Lordship, can you see the order item number 2? Last order of the item in WPC, last order of the item number 2 month, WPC 34/2025 month. They're supposed to give my lordship that I have been gone to Bangladesh. From there, how I enter in Kokrajhar. How, if there is any. Because I have gone to meet with Lordship as per the order of the court, my lordship. Yes, yes. Yes, yes. No, 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 my, sorry, mother, big apology. My, yes, yes, correct, correct, ma'am. My question is that if I have been sent back to Bangladesh, so where is the document shows that I have been handed over to the border force of Bangladesh, my lord? And then kindly see the last order, and I have also filed one IA in this case, my lord, for fresh bail, my lord. In item number 3, my lord.
Yes.
Yes.
Item 4.
Yeah, Mr. Lordship. Lordship, in this case, Miller, this is contempt against the order of the family court, Miller. Miller, the order is at page number, Miller, 11.
Oh, four already we passed some orders. In item 4, we passed some orders.
In the last, actually, notice was being issued, Miller. As per 8 September 2025, Miller, notice was being issued, Miller.
Oh, acha.
It also allowed for dusty service also, Miller. And we effectively did dusty service on 18 September, Miller. And we filed the affidavit of dusty service yesterday, Miller.
That is not on record.
Miller, we have called for mention, it may be possible for a timely, Miller. It was already called for it. I'm so obliged, Miller.
Item 6.
Lordships, in this case, my lord, I have received parawise command in morning time and status reports also I have received.
Hmm.
Status reports and parawise command in morning time I have received. You will also be directed to file affidavit also, but morning today I have received. Status report also is there. They arrested for another case.
You have to file an affidavit.
No, morning time I have received that parawise comment.
Okay.
Um,
How much time?
10 days time.
10 days.
Your lordship is on 10
You
days.
File it. Okay. You Mr. S.H. Siddharth. Mine. Mr. S.H. Siddharth and counsel for the petitioner. Mr. Next para. Mr. P. Sharma, an additional senior government advocate, has submitted that he has received the parawise report as well as the status report. And he-
Today, my lord.
Next para, however, and sorry, we can say the comma which is produced before the court. Next para. In view of the nature of allegations made in the writ petition, comma, filing of an affidavit is by the respondent is preferable. Respondents is preferable. So accordingly, the instructions produced are returned. Next para, the learned additional senior government advocate pays for 10 days time to file an affidavit in the matter. List on 27,
29, my lord. 29.
29. Okay, 29, 10, 25. Thank you. We are returning you this.
Oh,
Seven.
But matter was earlier hard. Even was not believed. I have earlier submitted our written argument, but I find that there are in the earlier written argument, there are some typographical mistake. So, my lord, I am arguing that case.
Hearing pura, lompa hearing, huh? Hearing police. Hearing police. TVS,
You want us to discard this one?
My lord.
You want us to
Earlier
discard this
to
one?
be discarded, my lord. There is some technical mistake.
Yes.
My lord, here it states, my lord. The improved opinion at page 60. Parents are voter in 1960, 70. And in the subsequent voter list, but subsequent voter list was not produced. Out of some oversight or mistake. Input nominal also find at page 60. But shortcut, my lord, I want to read the 11% only. The paragraph under paragraph 2 claims of the proceeding in the written statement. What has been stated in the written statement that has been quoted. And nothing to make any remarks on the statement reported.
Mr. Siddhar, you are not audible.
My lord.
You are not audible.
Sorry, my lord.
Let's speak
Now, my lord.
loud and clear.
My lord. So under paragraph 2, the claims of the proceeding in the written statement, this is this paragraph, the what has been stated that has been simply quoted, nothing to make any remarks on this, but quoted also that there was a shipping and fact of shipping was also in the WS and in this paragraph also mentioned. Then my lord, paragraph 4, discussion and decision reasons for decision in support of her claim as narrated by her in the written statement. The proceeding has examined total 3 witnesses, including herself, as DW1.
Where is the written statement?
My lord,
Written statement is in which page?
written statement also lordship will find uh, at page uh, at page 16, my lord.
16.
16.
But in this written statement, we have asked you because this written statement contains documents marked as exhibits. That's why we are asking.
Yes, my lord. My lord,
So
the
that is
trial
how-
courts, yes, it's a mistake, my lord.
Okay, okay. So we asked you only because of that.
But in written statement, he stated that he was born in village Mespara, which is their parental original place of residence. Subsequently, she was brought up in Halangbari, and the family shifted.
So may I come to my lord to the judgment again?
Yes.
My lord. Discussion, decision and reasons for decision. In support of her claim, as narrated by her in written statement, the proceeding has examined total 3 witnesses, including herself as DW1.
Yes.
In page 62, my lord. In 3 witnesses, including herself as DW1, Sri Utpal Ramshari, the government Lord Gaubura of village Salangbari in the district of Borbeta, Baksha, BTAD examined as DW2 and Mohammad Jamal Khan is examined as DW3. I have considered materials on record very carefully and cautiously. I have also heard the arguments advanced by the learned counsel of both the sides. Before proceeding any further, it would be appropriate at this juncture to scan through the evidence on record as produced by the proceeding. Evidence on record. According to the proceeding, Mrs. Lal Banu Begum, DW1, she is citizen of India by birth and a permanent resident of village Kopnikosi in the district of Kamrup. And prior to her marriage, she used to live in village Solangbari in the district of Borpeta. That she was born in at village Mespara in the district of Borpeta. That she got married to late Ainal Khan, son of late Nasir Khan of village Kopnikosi. That the proceeding used to cast her vote since 1985 under 55 number Hazu LSC, village Kopnikosi. That she is daughter of late Muslimuddin and late Shukurjan Nesa, granddaughter of late Dobiruddin, that her father died about 20 years earlier and her husband died about 10 years earlier, that the parents of the proceedings name were recorded in the voter list of 1966 Exhibit D, 1970 Exhibit E, under 50 number Borpeta LSC, that the parents of the proceeding had shifted from village Mespara to village Salangbari when she was about 10 years old, that the correct name of proceeding is Lal Bhanu, but in some documents her name was recorded as Lal Bhanu Begum in place of Lal Bhanu, and her father's actual name was Muslimuddin, but in some documents his name has appeared as Muslim in place of Muslimuddin, and her husband's actual name is Ainal Khan, but in some documents his name has appeared as Ainal Khan in place of Ainal Khan. Exhibit F is an affidavit sworn by the prosecutor. During the cross-examination, DW1 stated that at present she is residing at village Kopnikosi, that after her marriage she used to cast her vote at village Kopnikosi, that she has 2 brothers, namely Hakimuddin, Sokomuddin, and they cast their votes, and as such she will produce their voter list before this tribunal on the next date, that she is the daughter of late Muslimuddin and Shukurjan Nesa. Sri Utpal Ramshari, the government Gavura of village Holangbari, stated that she was appointed as Gavura about 5 years earlier, that he knows the proceeding for about 19-20 years, that the said proceeding used to cast her vote at village Kopnikosi. During the cross-examination, DW2 Ramshari has narrated that he was appointed as Gavura in the year 2011, that he knows the proceeding before he was appointed as Gavura, but he does not know in which year he got married. That Exhibit A is issued by him. Mohammad Jamal Khan, DW3, son of late Belu Khan of village Kopnikosi in the district of Kamrup, has narrated that he knows the proceeding since 40 years ago, that the proceeding used to cast her vote since 1989, that she is the daughter of late Muslimuddin and late Shukurjan Nesa. Further, DW3 narrated that proceeding is his relative. During the cross-examination of DW3 stated that the proceeding is his auntie, that he knows her after her marriage, that on the request of the proceeding he adduced his evidence before this tribunal. The father of the proceeding died about 12 years earlier, that the father of the proceeding was residing in village Holangbari. Appreciation of evidence on record. At the very outset, it is noticed that the Exhibit H, which is exhibited by the proceeding as NRC 1951, on close scrutiny, the same appears to be photocopy of NRC entry certificate. That being the position, the exhibit is cannot be accepted as proper document. Lordship will find, I have gone through the records. This is not a photocopy, mere photocopy. During cross-examination, the proceedee has narrated that her father, late Muslimuddin, son of late Dobiruddin, cast his vote in the year 1966, Exhibit D, and in the year 1970, Exhibit E, under 50 number Borpeta LAC at village Mespara. My lord, this part of the discussion is very important. My lord, because there has been is very lower level arithmetical calculation regarding the year of birth assessed from the voter list of 1966 and 70. Therefore, my lord, this is very important, my lord. This paragraph. In the exhibit D, age of her father was mentioned 40 years. So it is the age, the year of birth has been calculated 1960 minus 40. My lord, result shown is 1924. The absolutely wrong calculation, my lord. How it can be 24, my lord, to be 1926. Then, my lord, in exhibit E, his age was 40 years, 44 years in 1970 voter list, and calculation has been shown 1970 minus 44. Result shown 1934, date of birth. This is also a mistake. My lord, a minor calculation, arithmetic, my lord, class 2 standard calculation. The member unable to do it, my lord. And exhibit B, his age is 91 years. 91 years and result shown 1906, date of birth. Admittedly, my lord, the 1991 years, it is mismatching, it's apparently shown mismatching. But there is a reason. There has been an explanation also. Because that voter list, 70 voter list, 1997 voter list was produced later on. When the WS has been filed, evidence has been filed, the tribunal has asked to produce some more voter list, showing the brothers with the parents. And that voter list was simply placed before the tribunal without any explanation. Thus, there is no serious contradiction regarding that. There is a serious contradiction regarding the date of birth of her father. DW1 also stated that her grandfather's name was Dobiruddin, but in the voter list of 1997, her grandfather's name was shown as Dobir. DW1, the proceeding stated in her written statement as well as in her evidence in chief that she used to cast her vote since 1985 at village Kupnikosi, but curiously enough, she has submitted only the voter list of 1985 and under 1955 Hazu LSC Kupnikosi in the district of Kamrup. The reason is as to why he has not submitted such voter list of other years cannot be clearly understood. Another important point, as stated by DW1 at para 8 of her evidence in chief, is that parents had shifted from village Mespara from district Borpeta district to village Halangbari, Borpeta district in the year 1970 to 1975, about 40 to 45 years ago. Why her parents had shifted to village Halangbari is not mentioned by said proceeding. In this regard, the proceeding has not submitted any documents, but has only submitted the voter list of 1997 of village Halangbari. Although the proceeding has stated that her parents had shifted to village Halangbari in the year 1970-75. Why she has not submitted the voter list of village Halangbari for other years can be তো কই আছে ওকে বেলে কিবা সার্চ করতে মুভি পয়েন্ট আউট করি না
কই থাকলে না হলো না হুম My lord, in this record, my lord, I have seen, I have filed some additional affidavit. Those affidavits are not found, my lord. I have not seen.
The papers are loose,
My
not
lord.
well kept. I find difficulty in reading papers which are not serially kept. I'm
Well-
just giving them to make it serial.
Hmm?
No.
Hello, sir. Hey. Let me repeat it. Yes, yes, yes. Hmm? Hmm. Hmm. একটু বিষয়তে একটু Well,
Please continue.
well. Should we continue, my lord?
Yes, yes.
I am reading in my lord page 65. Another important point as stated by DW1 at para 8 of her evidence insist that her parents had shifted from village Mespara, Barbara district to village Halangbari, Barbara district in the year 1972-75, about 40 to 45 years ago. Why her parents shifted to village Halangbari is not mentioned by said proceeding. In this regard, the proceeding has submitted any documents, but has only submitted the voter list of 1997 of village Halangbari. Although she has stated that her parents had shifted to village Solangbari in the year 1970-75. Why she has not submitted the voter list of village Solangbari for other years cannot be reasonable be understood. But it is found from the evidence of DW2 and DW3 that the father of the proceeding had shifted to village Solangbari, and it is only plea made by DW in her evidence. In the light of above discussion, the proceeding, Ms. Lal Banu Begum is found to be failed to discharge her honors of proof as provided under Section 9 of the Foreigners Act 1946, that she is not a foreigner, as asserted and claimed by her, and therefore the point for determination as framed above is decided in affirmative. Accordingly, the proceeding, Mrs. Lal Banu Begum is held and declared as foreigner, and therefore she is liable to be deported from India and is due course of law. My lord, this is the conclusion. I declared her to be foreigner, although her parents are voted in 1970. Only point is, my lord, has highlighted by the tribunal that why not voter list of only voter list of 1997 in between after 70. So, and there the another point is discrepancy of age of her father in the voter list of 1970. My lord, kindly have a look at, my lord, the voter list of voter list of 1966. Lordship will find, my lord. Jasmine file to Bihana. সর্বন্ধ সোনার 1 বা 2 যেকোনো একটা ওলালে হল 1 হলেও হবো 2 হলেও এইটু বোধ হয় 1 সি দেবে একটু ঘুমিয়ে গেছে একটু প্ল্যান ও না ঠিকই আছে প্রিন্ট করবো ও আমি ঠিক করলাম সব ভবিষ্যৎ তোমার ঠিক আছে যাতে জাজমেন্ট কোনটো আছিলে মাই লর্ড voter list of 1966 lordship will find at page 24. Here, father is Muslimuddin Dobiruddin, mother Shukur Jannesa Muslimuddin, Habibuddin the paternal uncle, village Mespara. Then my lord 70 voter list at page 26. Muslimuddin, son of Dobiruddin, Shukur Jannesa, wife of Muslim. Here, father's name written shortly against her father, mother, my lord. My lord, here, my lord, the age 70 and 66 is no, my lord, variation, no discrepancy, my lord. My lord, I have annexed a voter list, my lord, 85 voter list. Lordship will find in page 68. This is admittedly not produced in evidence, my lord. But we have produced here, my lord, as a clarification, my lord. Page 68. In the same village, no, my lord, it is Holangbari. There is a plea of shifting, my lord. Muslimuddin, son of Dobiruddin, is 59. This has also, my lord, the age entry in the voter list is having consistency with the entry made in 66 and 70. Here, elder brothers appearing, Hakimuddin. Only, my lord, the fault is that in 1997 voter list, the age entry is mismatching. And the procedure was helpless because,
You had referred to the age discrepancy in the voter list.
my lord,
Which is that exhibit?
my lord, that is, my lord, 97 voter list, lordship will find in at page 58, my lord.
No, you had referred to the discussions by the tribunal, and you said that it's a typing.
Yes, my lord. Calculation, miss, my lord. That is with regard to 66 and 70.
Which page?
Page 24, my lord.
24.
24, 66 voter list. Age is 40
Just
in 1966.
page 28 is a type copy of 85.
My lord, 20 is a 85 voter list, my lord.
Yes.
85 voter list that relating to the proceeding in her parent, her matrimonial house, my lord, with
No,
her
no.
husband.
You had referred to the arithmetical error.
Yes,
We
my
want
lord. With
to-
regard to 66 and 70 voter list, my lord.
Hmm?
With regard to 66 and 70 voter list at page 24.
Page 20?
24, the 66
24.
voter list. The calculation is shown in my lord on page 64 of the judgment under appreciation of evidence on record. Kindly have a look, my lord. This is 66 voter list. Father's age is 40 and calculation at page 64. '70 also, my lord. Wrong calculation.
This there's some mistake. I am unable to catch exhibit. It's exhibit A is the Gambura certificate.
My lord. Exhibit
Which page is that?
my lord, Gavura certificate,
Is it page 32?
my lord. 32. Yes, my lord.
Okay. This Gambura came and deposed
Yes, came and deposed.
as DW2.
DW2, my lord.
And what is exhibit B?
My lord, it is the Gabra
Certified
certificate has been exhibited.
85. 1985.
85 brutalist is the brutalist of the proceeding herself
It's okay.
with her husband.
That is at page 29.
Yes, my lord.
He's 30 years.
Yes, my lord. 30 years. 85, 30 years.
Then exhibit C is the epic. Exhibit D is the voters list of 1966.
Yes, my lord. Exhibit the brutalist of 1966. Exhibit
It says
E is the
page
brutalist of
25.
1970, my lord.
That is at page 25.
My lord.
Exhibit E. Exhibit D is voter list of 1970.
My lord.
That is at page
Brutalist of 1970 at page
27.
26. Vernacular at page 27.
Then exhibit F is an affidavit.
Yes, my lord. There has been an acceleration of name correction, but affidavit has been is there, my lord, that has not been considered.
Then exhibit G is voter list
This
of
is brutalist of
1967.
1997. My lord. Tribunal has come down heavily on that.
1977 voter list is at
1997 brutalist, lordship will find at this at that is at page 58.
58.
My lord. 97 is here, it is vernacular, but certified copy is in the record, my lord. Tribunal find, my lord, recorded finding about the age discrepancy of father and name discrepancy of grandfather. Father, grandfather ought to have been Dubiruddin, here it is shortly written as Dobir. But mother's name is there, Sukurjan. Brother Sokimuddin is shortly written as Sokim.
This 1997,
In the record, it is there, my lord. টাইম বিং কৰি ভাল লাগিব চব তাল উদাহৰণ নাই সময় উঠিব বেলটো উঠিব বেলটো তুমি যোৱা তুমি যা কিন্তু তুমি লগলে গুচি আহিবা লগলে গুচি আহিবা এইটো ইয়াতে আহিবা My lord. My lord, in this case, my lord, the petitioner has filed a review also. Review also containing inter alia that the age entry in the 97 brutal list, there was a mistake. As per survey report, it was 71 years. And he has, to that extent, she has also submitted an RTI application to furnish a copy of the survey report. Survey report has not been furnished, and by filing review, he is demanded that the survey report may be called for and verify the actual report collected during survey about the age entry of father in the year 1997. That was not considered also. The learned tribunal has not considered. So, my lord, by adopting a strict rule and picking up the discrepancy of 1997, the view taken is not proper. And we have also produced
under the election guidelines, those forms which are filled up, survey reports and all, those are not required to be kept after the elections are over. It's
So-
not mandatory required to be kept.
But
Because claims and objections come in the, when the final voter list is prepared. So after that, those are all redundant.
that may be, but the procedure is suffering because of
No.
one wrong entry.
No, we understand.
And 85 voter list, we have also, my lord, here next in the writ petition. The 85 voter list is age entry having consistency with the 70 and 66 voter list. my lord. 85 voter list, lordship may kindly have a look at page 69.
Seen that.
This has the consistency with the 70 and 66 voter list. Page 69, my lord, translated copy at page 68.
Okay.
So, my lord, under this factual background, my lord, the claim of the proceeding that our parents are voter in 1966 and 70 has never been denied. There being no denial cross-examination to that extent, my lord. So in the light of the full bench decision, paragraph 120, paragraph 117.3, 117.4, and 112.1 and 122.2 paragraph of Muslim Mandal full bench judgment. My lord, when there is no denial cross-examination,
Paragraph.
paragraph, my lord, 117 of 2000, 117.3 full bench judgment tool like this one. Kitab to ase to,
No, we have it. Just give the paragraphs.
my lord. It is also in 112.1 and 122.1 and 122.2 full bench judgment to ase ni kiska ase?
4 paragraphs, 117.3, 112.1,
My lord, 122.2,
122.1,
122.2.
please come again, 117.3,
My lord,
117.3,
117.3, 117.4 also, my lord.
117.4. Yes, then
Then, my lord, 120.22.1 and 122.2.
okay.
Abdul Matalikul Wais classroom. তাৰপিছত Idris Ali to আছে না? My lord, we are also relying, my lord, on the decision of division bench judgment led by Honorable Justice Unima Hazarika. That is Abdul Matali case, my lord. Abdul Matali case paragraph 10 is relevant, my lord.
What is the citation?
My lord, 2015 2 GLT 617. Paragraph 10, my lord. My lord, may I read out the relevant portion of paragraph 10? I'm not reading the entire one, my lord.
Mr. Pang, please read the order dated 3/5/2016. 3/5/2016.
Availability of pink indicate.
But, I'm sorry to say, this is sorry state of affairs.
Printer in
In fact,
pink back to the
My
bottom.
lord, it's, if I may submit, my lord, on the, beyond the record, my lord, it may not.
No, it's okay. We just told you nothing. You're not doing anything. This 2016 matter,
Yes,
but this is one of those, what you call, meta glasses, which looks only on those.
there are complaints, my lord. There are complaints from.
It's
family
okay.
members. This stationaries, this
It,
supplies.
now pre-launch, pre-booking, what do you call, pre-launch booking is going on, meta glasses.
Dismiss করে দেওয়া লাগে পাওয়া লাগছে আর বেল্টু গালি খাবো ভোটার গালি খাবো কারণে অ্যাবসেন্ট হ্যাঁ 11:50 এই ওনার কথা হুম পাবো হলো নাই আচ্ছা একটু বিষয় কি দিই এদিকে করে একটু দিলা আচ্ছা তারপিছত তোমার আইদার একটু না লাগে তরঙ্গের সোনাল টুবি সিরাজুল ভক্ত সব
No ink in cartridge, not print out. So if you do it. So Siddharth, you said something about an affidavit which you filed, you said that it is not available.
My lord, yes, we filed some affidavit, my lord.
Which
Uh,
affidavit?
Yes, my lord, three affidavit we have filed. One is, my lord, on December 2017. Another is,
Before the
Step-
tribunal or before this court?
no, this old court, my lord.
Oh, acha. Okay, I was searching for that in the record. Okay.
2019 also showing upline and downline voter list of. Wait to select.
2017, that is available here.
17 is available. But then, my lord, September 19 and
September
November-
19 is also available.
2023 November, my lord. One is 2023 November.
That is also available.
My lord. Then I have, my lord, maybe my mistake, my lord, I could not see. My lord.
No, it's there.
My lord, I was referring the case of Abdul Mutali case, paragraph 10. The lordship has gone through on several occasions. Here this honorable court has held that the doubt, if any, which might arise in the mind of a tribunal must be answered not like a common man, but like a prudent person who is trained in law. In the instant case, on the face of the evidence on record brought forward by the alleged foreign national was unduly interpreted against him merely on the basis of some discrepancies as regard the age of a person concerned recorded in such documents. It is to be noted that those persons concerned, including the appellant, were not the writer of those documents. The ages so recorded in those documents no doubt point out discrepancies, but they are not so major or as to totally disbelieve, disregard, and belie the evidence of the appellant petitioner, so as to disrobe the precious most right of a citizen of country. My lord, here in this case, my lord, the tribunal has wrongly interpreted the year of birth from the 66 and 70 voter list. Admittedly, my lord, there is a mistake in 1997 voter list. And for that, he has made an effort raising claim in a review application that 91 voter list, 97 voter list that was produced after closing the evidence. My lord, while during cross-examination, second time, the tribunal asked why you have not produced any voter list of subsequent period. Then he produced the 97 voter list almost after the closing of the evidence, my lord. So there could be no possibility of making any explanation of wrong entry in the 97 voter list. But in review application, he has raised in paragraph 6, I think, my lord, in paragraph 6 of the review application, that he has made there has been an RTI application, and they have the knowledge that the entry in the survey period, it was 91, but while printing, it was wrongly written as 91. The tribunal has not considered it. At least the 85 voter list perhaps in a review application was produced. But these things are not considered at all. And rather the 66 and 70 voter list age entry has been wrongly calculated and taken a negative view, my lord. And my point is, when proceedee, an elderly lady, she is claiming to be citizen by producing voter list of 66, 70 of her father, her mother. And there being no rebuttal evidence, no cross-examination, merely some mistakes should not be picked up to disbelieve the whole evidence, my lord. And to that extent, my lord, the Sirazul Haq case, my lord, I am relying, my lord. I do not want to quote it, but I have mentioned in the written argument, Sirazul Haq case, my lord. That may be also looked into. Then, my lord, there are other judgments. the judgment of the Idris Ali, my lord. Idris Ali decision in WBC number 4116/2019 is judgment dated 27/2/2020. This honorable court held that 27/2/2020 in WBC number 4116/2019. In the internal page of the judgment,
Please give
para
the
five-
case, please
my
give the case number again, WBC
WBC 4116/2019.
of 2019.
My lord.
What is the name of the party?
Part Idris Ali versus Union of Indian Others. Decision is dated 27/2/2020.
Yes.
My lord,
Paragraph?
paragraph, my lord, in page, there is no paragraph number, page 27, referring a judgment of Supreme Court, this honorable court held, my lord, with an observation, I am reading, my lord, reverting to the case in hand, the strict rules of evidence are not applicable in a tribunal. Nothing is required to be proved beyond all reasonable doubt. These two lines, my lord, very important, my lord. And the learned tribunal not only miscalculation, but also undue interpretation. And there is some mistake in the 97 footage that was taken a plea in the review application that has not been looked into.
Yes, Mr. Pine.
Well, probably, I have only one submission, my lord, because my learned friend has argued a long matter. Only to point one thing, my lord. Even though, my lord, the 1966-71 voter list is there, only point here to be, my lord, whether the petitioner could link herself to the projected father or not. To link herself, she has submitted only one document. That is the, my lord, the Gawabura certificate of, that is exhibit, my lord. That is only the Gawabura certificate. Apart from that, my lord, page 32, my lord.
Just one.
Other things are lots of them, my lord. Ignoring all other discrepancies, there are lots of discrepancies with regard to my lord projected brothers and sisters. In fact, one of the project petitioner says he has two brothers. Gawabura says he has two brothers. My lord, one of the relative of the petitioner who came as to depose DW3, he says he has only one brother.
No.
Yes, it is there. I can show, it is in the record. That's why,
It is there. He gave
is there.
only one brother.
only one brother. It is said by
Yeah.
DW3 man.
Your nephew,
Nephew,
BW3, comes and says one brother.
yes.
My lord,
Only point, my lord, apart from all this,
my lord,
only
that
one,
person is hailing from her matrimonial side, my lord.
no,
Whatever
whatever it is,
he says one.
one, that's, my lord, the only point, my lord, whether the petitioner could link herself to the projected parent. That for that reason, my lord, he has brought only page 32 document. The Gawabura came, but Gawabura, my lord, if your lordship see, Gawabura is aged about 28 years. He has not brought any record. He has not given his evidence on the basis of, my lord, any contemporaneous record. In that case, his personal knowledge cannot come beyond, my lord, if a person is of 28 years, his personal knowledge cannot come beyond 20 years, my lord. At best, in the 8 years, he can understand something. So whatever he stated, that cannot be, my lord, those are also, in fact, this honorable court has in numbers of cases, my lord, said this cannot be accepted. And number three, secondly, my lord, this document is not admissible at all because this is the national emblem is embossed in the top of the certificate, page 32. This is settled by this law. This is not an admissible document.
We'll take a short break and come back.
Yes. But in fact, I have submitted my written argument, so I'm not going to elaborate other things, my lord. Other discrepancies are there, but only one point I would like to point out, this is of this judgment, my lord. This is Phalu Das, my lord. Was reported in fact. Yes. Yes. Yes, DW2. This is the Gaon Brahman. Yes. Yes, ma'am. This certificate, ma'am. Not the certificate copy, the certificate. Yes, ma'am. Yes. $32. Yes, madam. Yes, madam. That's why, madam. Yes, but he has definitely, he has clearly said he has not affixed during the time of, he did not affix this copy. That is also not. He has also said, I have not signed. Yes. The seal is there, madam. I'm not saying, my lord, there is, that's why I'm saying, my lord, this document cannot be admissible. Yes. For the national emblem. Yes, it's the. Yes. Whatever it may be, my lord, but he has said he has not affixed the photo and he has not signed it. My lord, in particular, piece 47, মই দিয়া প্ৰমাণ পত্ৰখনত, it is clearly said, not in my certificate which I have issued, পত্ৰখনত সংলগ্ন হৈ যিখন ফটো আছে তাত কাৰো নাম লিখা নাই আৰু মোৰ সই নাই. No, it is not. Translation is wrong, my lord.
Translation is wrong.
Translation is wrong. My lord, the certificate as per this, মই দিয়া প্ৰমাণ পত্ৰখনত সংলগ্ন হৈ থকা যিখন ফটো আছে তাত কাৰো নাম লিখা নাই
Yes, that's okay.
আৰু মোৰ সহি নাই.
That's okay.
Translation is wrong. Sorry, my lord. So, with this regard, my lord, and this certificate is issued on, my lord, 16/12/2015. That, yes. And this 15/7/2015, why I am pointing out this, my lord, the proceeding, my lord, initiated in 2003. And this certificate issued in 2015. That point is also there. In Phalu Das, my lord, in WPC 1157 of 2018. Para 22, my lord, that point is dealt with. WPC 1157 of 2018. It is, I'm just reading the document which was obtained 15 years thereafter. That means, my lord, the firstly, we have already seen Phalu Das, my lord, 1157 of 2018 reported. This is a reported case, my lord, but I cite named Phalu Das, my lord, FALU. LU. Phalu Das. Union of India, my lord. Reported, my lord, I don't have the citation. WPC 1157 of 2018, my lord. Judgment dated, my lord, this is 9/4/2018. Paragraph 22, my lord. 22, my lord. Lordship may kindly see. It was at the point of Exhibit 8 was introduced in the petition. That is the Gaobura certificate. That is also. The document cannot be accepted as a valid piece of evidence for more than one reason. My lord. Firstly, we have already seen the reference against the petitioner was made as per Beck as on 28/0/2002. The document was obtained after 15 years, obtained 15 years thereafter in the year 2017. Same is the case in the present case also, my lord. The case was initiated in 2003. This certificate was issued in 2015. Such belated issuance of Exhibit 8 certainly caused serious doubt about the bona fideness of such certificate. That apart, Gaobura did not testify before the tribunal on the basis of contemporaneous record to prove Exhibit 8 as is and its contents, including truthfulness thereof. So the petition here also, Gaobura deposed, but he did not come along with contemporaneous record. However, even if we accept this certificate as its face value, it's only say Palu Das was this part is not necessary because there the husband name is shown, my lord. So for this reason, belated issuance, my lord, not bringing the the contemporary record to prove the case will not, my lord, will make this certificate inadmissible. Secondly, my lord, with regard to this, even in this case also, the national emblem was there for the issue of national. Yes, para 32, my lord. Taken judgment, my lord, with on this point. There are numbers of judgments. Only 2 relevant judgments, my lord. This is Lilia Khatun, my lord. WPC 7698/2016, my lord. Laila LAILIYA, my lord. Lilia Khatun. KACTUN Khatun versus Union of India. There is Elias, my lord. WPC 7698/2016. This is decided on, my lord, 11/6/2018. There your lordship will find the in this judgment, my lord, there is no numbering, but page 5, my lord, it is page 5 of the judgment. Second para onwards, my lord. Lordship, page 5, my lord. In his deposition before tribunal DW2. That's all. Exhibit A is a certificate dated 9/11/2015 issued by the Gaobura certifying Mohammed so-and-so. The certificate carries serial number so-and-so. In his deposition before the tribunal, DW2 Moniruddin stated that he was the Gaobura and that he has issued the Exhibit A certificate, but not going through the entire evidence of DW2. It is seen that he has issued Exhibit A certificate on the basis of personal knowledge. But interestingly, he did not say, and the certificate is also silent about since he knew that Jalaluddin. DW2 might have owned Exhibit A certificate that would not ipso facto mean that contents of the certificate were proved. The contents would have to be proved on the basis of contemporaneous record. The content has to be proved on the basis of contemporary record. Mentioning of serial number so-and-so in the certificate is indicative that previous certificate were issued. That is not necessary. The register was required. Then, madam, the register was required to be produced before the tribunal, and the contents of the certificate was then required to be proved from the register, but that was not done. It is to be borne in mind that contents of the certificate would have to be proved from the record, though the author of the certificate may have to prove the documents through oral evidence. my lord, have to prove from the record, though the author of the certificate may prove the documents through oral evidence, but oral evidence divorce record cannot prove content. Contents of documents based on record cannot be proved from personal knowledge. Therefore, contents of Exhibit A cannot said to have been proved. The next paragraph, my lord, this is with regard to, there is one more aspect which we have noticed. The state emblem of India is embossed on the middle of the expression Assam government under Rule so and so of the schedule of the state emblem of India regulation to use rules 2007 framed by the government of central government in exercise of a power conferred by section 11 of the state emblem of India prohibition so and so. Gaobura is not authorized to use the state emblem of India in any manner. Therefore, embossing of the state emblem of India in the certificate is unauthorized. Such unauthorized use of state emblem of India has rendered Exhibit A inadmissible in evidence. Thus, Exhibit A was not only not proved, but also inadmissible in evidence. So, my lord, if this document is inadmissible, my learned senior friend has argued that, my lord, it is not rebutted, no cross-examination is done with regard to this point. If the documents, my lord, the admission, my lord, evidence itself is not admissible, there is no question of rebuttal evidence. First of all, he has to bring evidence which is admissible, cogent, and reliable. Then only, my lord, there needs to be cross-examination or, my lord, rebuttal. Otherwise, it is not necessary on the part of the state to rebut the, my lord, on the basis of inadmissible record or inadmissible, my lord, evidence. So if this documents is, my lord, not there, the documents is not there, the, my lord, Gaobura certificate and evidence of Gaobura, then there is no document or no evidence to link herself to the projected parents. I'm leaving aside, my lord, we have given, my lord, the written argument. We have given other aspects. I'm not going to argue on the other aspects. All are there. Only this is the crux of the matter, my lord. If this can be proved, there is other we can ignore also. That's the only point.
Well, I want to make a short submission, reply submission made by friends. My lord, my friend has heavily relied on the certificates, particularly the state emblem embossed on the certificate, and relying on this on some judgment that when the state emblem is embossed, the certificate is invalid. My submission is that the judgment should not be one-sided. When the honorable court has said that this judgment is invalid, these documents is invalid because there is state emblem, and the state that documents issued by not by an ordinary person, but although a Gaobura, but he is under the government, and a person under the deputy commissioner. So, my lord, what action has been taken? The judgment is totally silent as regard the issuance of these documents. No whisper whether the authorities are restrained to issue the certificates in future. That has not been. So this judgment is not a good law. It cannot be accepted as a good law because it is a one-sided judgment, only to make a person foreigner due to some lapse or some discrepancy or lacuna. This should not be. Judgment should be balanced. The judgment, the decision which has been relied on is not a balanced decision because the issuing authority has not been notified or cautioned that stop this issuance of this certificate. This certificate has been going on, issuing has been going on, and no stop to the authority. So this cannot be accepted as a good law. That is my own submission, well. And so far the documentary linkage, my lord, it's a citizenship case. Citizenship case, there has been judgment of the Supreme Court in the Sarvananda Sonal both 1 and 2. In 2, quoted the paragraph 26 of the judgment one, that when evidence has been laid by the proceeding, the other side is to rebuttal. My friend is saying that when there is no evidence cogent and reliable, so not rebuttal evidence is not is necessary. But it is absolutely wrong to say, my lord, when this honorable court in Idris Ali has said that strict rule of evidence is not applicable in the case of tribunal. My lord, then how it can be the logical point, my lord, that I have to prove by linkage. When my claim is based on 66 and 70 voter list of my parents, and that part has not been denied, no rebuttal evidence to my claim. And the full bench, as well as in the Sarvanda Sonal case, that claim should be rebutted by rebuttal evidence. That being missing, my lord, the linkage by documentary is not my lord, reasonable plea, my lord. And when women is ordinarily, my lord, women's poor background, they have no schooling, though no date birth register. They are married in a minor age before entering the voter list. There is no documentary linkage. Whether this point is to be thrown away. The state has no liability to consider this, because state has the obligation to protect the citizen, giving schooling or other facilities. That being missing simply on technical point, my lord, the claim has been denied. That is not proper, my lord. And my lord, so far the law point, my lord, non-production of documents and non-available of documentary linkage, it should not be fatal. My lord, I am relying on judgment, my lord. The judgment of O'Neill, Sharma and others. 2004, 4 SCC, page 679. Paragraph 13 is relevant, my lord. My lord. Citation, my lord, 2004, 5 SCC, 679. Paragraph 13. My lord, it is stated like that. Non-production of documents which the appellants claim would have strengthened the claim of absence of EW5 cannot in any way dilute the evidentiary value of the oral testimony. Even though the witnesses have been cross-examined at length, no material inconsistency has been elicited to discard the evidence of PW5 and 6. One of the pleas which has been pressed into service is the alleged relationship of PWs 5 and 6 with the deceased and their criminal antecedents. My lord, I think the first 3-4 paragraph is sufficient. My lord. My lord. My lord, sorry, my lord, I have only. Yes. itu আছে না আৰু কিবা আছে না itu আর আছে হাইড্রোলিটো প্রথম হ্যাঁ দিদি একটু ঠিক আছে My lord, in support of this point, my lord, I want to refer another case law, my lord. Paragraph 42, Roman 4 of hydraulic judgment. My lord. Paragraph 42, Roman 4 of hydraulic judgment, that is 2021 3 GLT 85. Hydraulic, my lord. Yes, my lord. HAIDAR. Hydraulic. Citation is 2021 3 GLT 85. 85. Paragraph 42 within bracket Roman 4. My lord, I am reading, my lord. Further, it is nowhere mandated that he must prove all these facts by documentary evidence only. Section 59 of the Evidence Act 1872 says that all the facts and except the contents of document or electronic records may be proved by oral evidence. There may be cases where the proceeding is in illiterate and the birth is not registered with any authority, in which event it would be impossible to produce any documentary evidence to prove his date of birth or place of birth and other facts accurately. One may rely on oral evidence only. In such case, can a claim be thrown out merely because only oral evidence has been laid. My lord, my lord, here my submission is that our country is not like USA or Germany or Japan, where 100% illiterate, particularly in except in India, in Kerala state, where there is literacy is high. In our state, my lord, literacy is very poor, and particularly the women, and belongs to this community. The procedure to which community belongs, but they are very poor, they're very illiterate. That part is being ignored, my lord. And if, my lord, that going on, my lord, we are helpless, my lord. We are helpless, my lord. And so this honorable court has rightly said that strict rule of evidence should not be applied in this case. That is my submission, my lord. I will give a contact. I know you have a problem. I will see my case.
Point to it is in the following. Please. Supplementary judgment উপর আছে। Supplementary. APP. My lord, one point, my lord, I have left, my lord. My friend is arguing on this point, but saying that the inquiry was in 2003, the report certificate, power certificate 2015 or like that. So it is up, the certificate is long after the investigation. My submission in this regard is that the lordship, if you go to the records, you'll find that the signature of the witnesses by the interrogating officer is not taken. Interrogating officer has not taken signature while recording their statement. And that is also violation of the full bench judgment. Full bench judgment in paragraph 97, in the middle part, has said the investigating officer, as far as practicable, shall also obtain the signature or thumb impression of the person against whom such investigation is initiated. So, my lord, this reference is false. It's a mechanical reference, and this certificate being of 2015 and inquiry of 2003, which the proceeding does not know at all. Proceeding does not know at all whether that can be taken as a negative inference. That is my point, man. So it is also a mechanical reference.
In 1.5, the joy does that much. It means this. If I have to look at 2018, whole scale say 97 months. Put figure for whatever evidence. Visual does. 2018, GLP 118 method. 2018, GLP 118. It's 2018, GLP 118. Better 17. That was left out, my lord. That there it is said, my lord, oral evidence Filing of written statement or oral testimony in proceeding under Foreigner's Act would not be enough. The fact in issue would have to be proved by proceeding by adducing documentary evidence which is admissible and relevant for that purpose. Obvious.
Heard Mr. A.R. Sigdar, learned counsel for the petitioner. Also heard Swenson for the respondents. Argument is concluded, it has been reserved. Let us see.
Item 2 with 3.
Mix is solo. Mix is. Yes,
I'm sorry, my lord, I was not there when the was called, my lord.
you have to give us the information
Yes, my lord.
by way.
What information is required, my lord?
What do you call the, the state says that the proceeding was taken into custody and handed over to the
Yes.
BSF for
Yes, my lord.
being sent back.
Yes,
So therefore, this is their communication.
my lord.
Yes, I have.
Yes,
Given
sir.
a copy.
sir.
I got it, my lord.
Uh, They were handed over, it says.
My lord. Day after tomorrow, my lord.
You'll be able to get it? Okay. Also is a represented in the learned standing counsel for the FT and Border Matters has produced a copy of communication dated 11/10/2025. And it is submitted that the detained foreign national, the declared foreign national was handed over to the Border Security Force, sector headquarter, Panbari, Dhubri on 26/5/2025. To project that the declared foreign national was sent back to to Bangladesh. However, the said declared foreign national had come back into India and he was subsequently taken into custody again and is presently lodged at the holding center of 7th AP Battalion, Saraifala, Pokrajhar. Next, let a copy of the same be provided to Mr. AR
ये बात है, ठीक है, my lord.
the learned CGC to enable him to obtain instructions. Next list on day after tomorrow,
Yes, my lord.
16/10/2025.
My lord, let him produce me a soft copy of the petition, my lord.
Okay,
I would,
give us
I
soft
will
copy.
get
of-
Xerox copy of one.
Yes.
Please, just make the learned copy of the learned counsel for the petitioner shall provide a soft copy of the shall give a soft copy of the petition to the learned CGC. In course of the day.
Manoj, can I give Xerox copy? I have, I will, right now, today itself, I will give the.
Okay, make it photocopy. Make it photocopy. Okay.
Deeply over.
But copy has been given. It is with, it's a Parashar.
Yes.
It's okay, but since you are taking only one day time to get it.
Timing item 4.
May I please your lordship? Lordship, this is a contempt matter.
But here in this case, my lord, I am for sole respondent. I filed dollar number today. My lord, I want to file affidavit in opposition. So sometime you will grant it.
Well, this is
Some days.
I'm Burman, my lords.
Counsel enters appearance on behalf of the sole respondent and prays for some time to file affidavit in opposition to the matter. Next, matter stands adjourned today. List on when?
My lords, a date may be given, my lords.
List on 29/10/2025.
I'm so obliged, my lords. Well, advance copy may be provided.
Oh, they will do it.
Yes, I'm so obliged.
I never pass an order
Yes, my lords.
how to serve.
Yes, my lords. I'm so obliged, my lords.
Item 8.
May I plead your lordship? My lord, this is contested case, my lord. On voter list is, my lord, page 11, my lord. Petitioner's grandfather's and grandmother name is recorded, my lord. Page 11, my lord. Voter list of 1966. Opinion. Opinion is, my lord, page 22.
exhibit Gha is in which page? That certificate,
Oh, yes, my lord. I have annexed, not annexed, my lord, in this petition, my lord.
okay. Was this Gambura examined?
No, my lord.
Is there any voter list of you along with your projected parents or grandparents?
No, my lord.
Then you have failed to demonstrate that you are linked with your projected parents and
That's not
grandparents.
entered after marriage, my lord.
No, we
That's why,
understand.
my lord,
We are not asking that question.
my lord. Before, my
in-
lord.
But
Before.
then the link must be proved by some manner.
Only Gaupura certificate is my lord linkage, my lord.
No,
No
but
other-
he was not examined as witness. Then everything fails. And this Gha, we wanted to see this specifically. You have the document? No.
No.
Just look at this document. Itu Esposita. Read the contents. Read it loudly. I'll refresh my memory.
My lord, সরকারি গাঁওবুঢ়াৰ পৰিচয় ইয়াৰ দ্বাৰা পৰিচয় পত্ৰ দিয়া হয় যে আম্বিয়া খাতুন
Yes. Porichoy Patra diya hai.
my lord.
Porichoy Patra in English would be identity card unless you show otherwise. So identity certificate is no certificate at all. And even in the third last line, same thing you will find.
Last উক্ত আবুল হুসেন 1970s before that.
I don't know, two or three lines in the from the bottom. Again, there is reference to Porichoy Patra.
এটো কি লিখে?
Again, there is a reference.
তেওঁকে পৰিচয় পত্ৰ প্ৰদান কৰি উজ্জ্বল ভৱিষ্যত কামনা কৰিলো। উক্ত আবুল হুছেইন 1970 চনৰ পিছত মৈৰাবাৰী বাস কৰি আছিলে। Last line it is my
So that is important because he gave you good wishes
lord.
for future.
Another certificate is my lord সরকারি গাঁওবুঢ়াৰ প্ৰমাণ পত্ৰ certificate my lord.
She's a resident of which village? She's a resident of village Sagun Bahi, correct? Now, this, there are three certificates,
Yes, sir.
Hao, Ungo and Cho.
My-
Those are not issued by
Not it,
the, the village Sagun Bahi. Now you see, the problem is somewhere you have written in your, somewhere it is written here in your this writ petition that in 1997
my lord.
they shifted due to soil, erosion of Brahmaputra. Correct?
My lord.
Somewhere you have mentioned, I won't be able to recollect where. This Brahmaputra erosion was there and therefore they shifted. Now, how far is that three Gambura certificate reliable? Because the name of your father and your grandmother, I think,
My lord.
were in the voters list of 1960 and 1970 of village Tengubadi number 1.
Oh.
So you see somebody who has been knowing your father, and grandmother, and they have seen that shifting. Only that Gambura can tell us. So that is there is not even the pleaded case. In your written statement, I don't think you have referred to this shifting. Paragraph 6, page 19.
My lord.
Due to erosion of Brahmaputra, her father lost landed property for which her father, along with her OP, shifted her family to Moirabari village under so and so. So that year is not there. Here, I have now seen it is there in your synopsis. The name of petitioner father entered in the list of 1997 where they shifted and settled due to erosion. So therefore, shifting took place in 1997.
Yes, my lord.
So this Gambura certificate doesn't help you. Even if we take your evidence, but this doesn't help you because this certificate doesn't show the linkage of somebody in Tengaguri, where you were born, to link you with
Right.
the projected parents. There's another reason. You see, you say that your landed property was lost. That means you'll have evidence of land which existed. That is not there. So you not only say that you have a name in the voter list, you say that the landed property were there which was lost. So the linkage is not there. Yes, please proceed. These were 2 or 3 queries which we had put to you so that when you make your submissions, you can articulate on that.
My lord, page 24, para 4, my lord, exhibit code is a certificate issued by the governor of number 1, Tengaguri. Tengaguri in this name of this OP, but this certificate is not proved, my lord. Concerned governor, my lord. If your lordship allow, my lord, demanded that this matter, my lord, proved, my lord, all the governor, my lord. Because my lord petitioner, she is a illiterate, my lord. First time entered his name is after marriage, my lord. Before not, my lord. No other documents, my lord. Only Gabuda certificate is here, my lord. No idea, no birth certificate or no school certificate is there.
Accept your statement. Then you see, as per page 10 of this writ petition, you are 42 years in May 2017. Correct. Therefore, you must have been born sometime in 1975 and you became eligible to vote in the year 1997. Was your name there in 1997 voter list? So 1997 voter list, your name is not there.
No, my lord.
not annexed. No, sir. No,
Total is not the next, my lord. Only, my lord, page 20, para 9, my lord. Only one para is there, my lord, but there is no- my lord. My lord, my lord. Rusmatali is my lord. Grandfather's. Yes, grandfather, my lord. Rusmatali is petitioner grandfather, my lord. My lord. Father's name is Abul Hussein, my lord. My lord.
This Abul Hussein,
My lord. Nothing is mentioned, my lord, in this.
In evidence, Lordship, it was mentioned.
Hmm?
In evidence part, it was mentioned, Lordship.
in evidence.
During the time of deposition, his father was alive, and during the time of deposition of DW2 Lordship, DW2 states that his father died 2 months before his deposition, Lordship. 2 months. Evidence.
Alexan, Madam,
Not mentioned.
Nurjahan Begum, Madam.
Received on 4 July 2015.
No. No, no, no. No. That Rusmat Ali is my lord, petitioners, my lord, husband, my lord. Both my not same, my lord. No, my lord, actually I have an ex, both name are same, my lord. Grandfather's name also, my lord, is same, my lord, petition. My, no, no. That is husband name, my lord.
No, বর্তমান জীবিত। Are un, are un, are- procedures only. I mean, grandfather. Rusmond was grandfather lot as per.
That's going to. No, my lord. Rusmot,
Yes,
my lord,
lord.
two Rusmot, one name, one is a
Husband name and
grandfather and husband.
grandfather
name
and
is same,
husband
my
names
lord.
are same lordship.
This is, we had missed it, this aspect was missed out. But when your father is alive, why would your aunt come and give evidence? Why not your father? Is your aunt's name recorded in any of the
No.
exhibited documents? No.
No, my lord.
Hmm? Sorry, अपनी पति क्या खत्म अभी खत्म करती है ये जो कुछ क्या खत्म Look, page 9 and thereafter page 10. 9 and then back page 10 and again back page. Do you see something? You notice something? No,
Noted, no.
you see DW1 is Ambia Khatun. Her LTI is taken in DW2 also.
Yes, no.
This has to go back to the tribunal, have the signatures of the correct witness taken and then got back. What to do? We'll send it back. Actual witnesses' signatures should be taken and returned back.
Okay.
Let's see. Just take down. Mr. Ms. Al Wazida, Lion Counsel for the petitioner, and so and so for the respondents are present. Next, in course of hearing and on perusal of the tribunal's records, we notice that the DW1 who was examined on 29/1/2016 is Ambia Khatun, AMBIA Khatun, KHATUN, who is the petitioner, and DW2, who was examined on 18/5/2016, is Jahura Khatun, JAHURA, Jahura Khatun. However, the left-hand thumb impression in both the depositions are taken of Ambia Khatun.
The whole of the role of Amgen.
Therefore, the said error on part of the Foreigners Tribunal Second Morigaon in maintaining the records is found to vitiate the impugned opinion dated so and so, that is page 22. Next para, accordingly, in the opinion of the court, no purpose would be served to refer to the pleadings and evidence and to examine and to appreciate the impugned opinion dated 30/11/2016 in light of the vitiation of the in- In fact, the opinion is, as indicated above, is found to be vitiated, comma, the said opinion dated 30/11/2016, passed by so is hereby set aside. And the matter is remanded back to the learned member, comma, Foreigners Tribunal, 5th Morigaon. Directing the said learned tribunal to re-examine the DW2 and thereafter to pass a fresh opinion in accordance with law. Next para. The petitioner, comma, who is duly represented by a learned counsel, is directed to appear before the learned member, comma, Foreigners Tribunal, 5th Morigaon on 7/11/2025 without requirement of any further notice of appearance. On such appearance, comma, the learned tribunal shall issue summons to the DW2 requiring her presence for the re-examination. Public fresh examination, fresh dash examination as DW2. Next para. As the evidence in chief and the cross examination of DW2 is under the left hand thumb impression of the petitioner within bracket DW1, comma, the same would stand expunged to stop, however, comma, without prejudice to the said learned tribunal to accept the same on record in the event the DW2 accepts evidence recorded on 18/5/2016 to be given by her. Next para, we made clear that in the event the petitioner fails to appear before the learned tribunal on the date fixed, comma, it would be open to the said learned tribunal to treat the petitioner as absent on call and proceed with the matter in accordance with law. Next para. The we request the learned standing counsel for the FT and border matters to transmit a downloaded copy of this order to the Superintendent of Police, border Morigaon, to bring the order to the notice of the said authority. Like yesterday, this also you'll have to tell them.
Yes, yes, okay.
Because
Scope.
earlier we have passed a judicial order that the superintendents and the bench assistant has to be trained. You remember? In one of the occasions, we had passed an order to the
Yes,
Home
yes.
Department to consider whether they should be also sent for training.
Yes.
But this is a mistake of the bench assistant.
Okay.
He, look at this record, will show you something more. in this thumb impression, you will find that there is some difference. It's not the same because they are taken on 2 days.
Yes, yes. Yes,
Correct. So they are a bit different.
sir. Different.
So it's a mistake of the bench assistant
it-
taking the signature of A and writing the name of
Yes,
B.
yes. In place of Jora Katon.
This is written.
Yes. Right.
So that's why we have said if the witness comes and undertakes that this is her signature,
Hmm.
then it can be taken on board. Otherwise, it's a press examination.
Right.
But this, you'll have to tell them that these people will also have to be trained.
Okay. Okay.
Did I make it here?
Yes, sir.
Okay, next para. Although this court is not recording a finding as to at whose instance the inadvertence had happened. But this would call for an examination by the state through its Home and Political B department as to whether they think fit and proper to have a training conducted for the superintendents of the foreigners tribunals and the bench assistants, so that such clerical mistakes do not happen. And don't happen, can be checked. Accordingly, we also request the learned standing counsel for the Home and Political B department to transmit a downloaded copy of this order to the said department to bring the order to the notice of the said authorities, concerned authorities. This stands disposed of.
Item 9.
Resolution.
Records of the tribunal will be sent back.
May I please your lordship? Lordship, I beg to mention item number 9. Lordship, kindly adjourn the matter for today because my senior is out of station. So kindly take the matter in any other day.
Just a moment. This is item number
Item number 9.
9.
Yes.
Something wrong here. You are making prayer on behalf of whom?
MU Mahmood.
There's something wrong.
Nine.
The advocate on record is Mr. A.R. Sigdar. was here, he argued a matter just now. You see, in the list of the advocates filing the Wakalatnama, the name of Mr. M.U. Mahmood is not there. We don't find his name on record. There's no judicial order, at least in this writ petition, acknowledging Mr. M.U. Mahmood as a counsel for the petitioner. It's not there. It's just not there. Wakalatnama is of Mr. A.R. Sikdar. After the writ petition. Just wait. After the writ petition, you will find the Wakalatnama. Name of Mr. Mahmood is not there. Although the cause list shows his name, we can't recognize him as a counsel for the petitioner unless his Wakalatnama is brought on record.
itu karena mau itu क्या है जो गलत मामला सेकंड साइड तो सेकंड साइड तो टाइम
list on 3/11/2025. The as per the case status, the afresh Wakalatama on behalf of the counsel for the petitioner was filed on 14/7/2025. You said Wakalatama shall be tagged by the registry on record. The printout of the case status is retained on record. Next para, list on 3/11/2025.
Item 10 with 11.
May I please your turn?
Just a moment. Mr. Additional Advocate General, you are here for a patent matter. Which is that item?
Well, the preventive bench.
Huh?
Not this bench, but on the next bench. Next bench.
Oh, it is in the next bench. Okay, okay. Okay.
May I please your turn?
Yes.
My lord, in this case, my lord, we are challenging the impugn order, my lord, that is annexure 4, my lord. On the ground that it is hit under the principle of res judicata, my lord. My lord, earlier,
What's
my
the
lord,
page number? Don't tell us the
my lord,
annexure
annexure
number.
4,
What's the page number?
annexure 4, page number 16 to 19, my lord.
Page number
16 to 19, my lord.
16 to 19. Okay.
Huh?
And this page 13 is the earlier order.
Yes, my lord. Yes. Page 13 is the earlier one, by which I was declared citizen Indian, my lord. Copy 9. How about just we?
Yes.
My lord, my lord, in the second proceeding, my lord, I've even submitted the, my lord, certified copy of the said order. That is exhibit as exhibit D, but that was never discussed, my lord. In the judgment.
Where is your written statement?
Now, here we have, in this case, we have not submitted, madam. In this case, we have not submitted. We are
Before the
only-
tribunal, you did not submit any.
No, tribunal, we have submitted written statements. Tribunal, we have also exhibited many documents, madam, that your lordship will, is reflected as exhibit A to H, my lord, in page number 17, my lord. 11 to. Take two, okay?
Mr. Sharma, this has to be remanded back. Exhibit D is not discussed.
No. That was possible. I don't have the file to the law.
Hmm?
I don't have the file. I have not gone through it.
Look, man, this is the. It is here. Page 16 is the. Huh? I think okay. Oh, acha, we'll have to rise. There's a bench notified. 3:15 we have to rise. Take it some other. You know, pass it to a time matter could not be taken up.
Division bench item 1 for admission.
My part was over your Lordship on last occasion. I have also submitted a written note on submission, Your Lordship. Giving the points which I have, and 2 volumes of your Lordship license I have provided. Apart from those judgments, Your Lordship, I would like to rely on one more judgment recently, Your Lordship, that passed, Your Lordship, in an NDPS matter, Your Lordship, not NDPS, under the NDPS section 2015 also. That I will, after completion of the submission of my, in your count.
Okay, yes.
In fact, on the last section, I also. You are one book. Not informed to the right.
Yes.
On the last section, in fact, I have covered most of the submissions and the points raised by the writ petitioner. My lord, in the one of the grounds taken in the writ petition is that by the in the detention order, it was mentioned that he has got a right to.
No, just a moment.
My lord,
Few good days have gone by, so
my lord,
let's recapitulate with what we heard of Mr. Bhattakur. You had referred to the detention order of 14/5/2025. And you're referring to the communication at page 49
Lordship.
that
Grounds of detention.
to make representation to 2 authorities.
Lordship.
And you say that the representation should be made to the
Detaining authority.
detaining authority that is not
Not
given to you, and so therefore you are prejudiced.
Sure.
And then
Secondly, Your Lordship,
you are referring to page 135 to 161,
Lordship.
affidavit in opposition of respondent 4. And that without any fresh document, the detention order was passed.
Sure. And
Correct.
those, what they have relied on, Your Lordship, by in the grounds of arrest, Your Lordship, all those documents were not been provided to us.
Not provided to
Not
you.
provided to us, and in fact, Your Lordship, just for Your Lordship, one aspect I have pointed out, Your Lordship, that Your Lordship will get it at page. Your Lordship, page 54.
54.
54, rationale for issuing detention order against Sri Aminul Islam.
Yes.
Your Lordship will, in para 2, Your Lordship will find. It demonstrates tenders and by making them Mr. Islam has disaffection against the government of India, expected that Mr. Community in the aftermath of speech on 24th of 2025. There were reports of protest and communal sentiments suspected in the intelligence of the people. This to be mentioned soon after the video went viral, certain comments, status, and communal in nature and tune with the contents of the video responded. For example, one person, namely Masum Azahar, son of Sirajul Islam of Penal Bazar under Khatwal PS district, Nagaon, uploaded an objectionable and derogatory comment targeting the Hindu community and threatening to oust them from country. The person has been arrested in connection with Khatwal PS case number so of BNS. The arrested person who confessed to have been influenced in both by viral video statements given by Sri Aminul Islam. Now, these documents were, Your Lordship, although Your Lordship, we have found place in there, your lordship, dossier, your lordship, that has not been provided to us when you confessional statement and other documents. This is one of the reasons why your lordship rationale they have given for passing the impugn order of detention. That has also not been met. And apart from that, your lordship, I have specifically mentioned lordship, lordship. I and your lordship, I have also pointed out your lordship from my your lordship will find at page 56 your lordship.
Yes, 2 years. The new place has to be identified.
Writing.
New place has to be identified.
Lordship. Lordship.
Maybe my learned friend.
That is one and your lordship will find at page 56. Lordship. And then your lordship, another ground was your lordship delay in disposal of the representative. Lordship. 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 $25. Lord. Lordship. After 12 days, your lordship. After 12 days, your lordship, I am informed about my right to represent. Lordship. Lordship. That point was your lordship is that your lordship, they have, if your lordship sees the page 47, the detention order, your lordship, 47. They have referred to a your lordship wrong notification of that. And on that point, your lordship, my argument is your lordship, slightest infraction will your lordship make this detention order, your lordship. Fair in law. Lordship. That is a confirmation by the state government, your lordship, and it was your lordship. For 1 year, he was detained, your lordship, by this order, your lordship. Lordship, 116, your lordship, and my point on that is your lordship that it lacks reason, your lordship. Although your lordship, there must be a reasoning why 1 year they have extended the period of detention to maximum period of 1 year, your lordship. That has not been there, your lordship. And one more point is there, your lordship, that your lordship will find it in the non-consideration of the bail order. The conditions imposed by in the bail order, your lordship will find the order granting bail, your lordship. That is at page 44, your lordship. Lordship, page 45, your lordship. There is a specific finding by the court, your lordship, regarding in page 45, second paragraph, your lordship. Page bail order is 14/5/2025, on the same date on which the order of detention was passed through. Page 45, second paragraph, your lordship will find. The statements allegedly made were not expected from any responsibility that are especially a public representative at that point of time from the level of or acts of terrorism made and being a public representative expected to be more responsible public being. Yet it has to be stated there is nothing to show that the statements made have resulted in the untoward. Then your lordship will come to page 46, the conditions, your lord. And this, your lordship, in your lordship judgment, recent judgment, your lordship has discussed about this point, your lordship, whether your lordship, the retaining authority ought to have been considered these conditions are enough or not, your lordship. We don't think so, your lordship. That judgment, your lordship, I have not furnished it after my your friend completes your file.
That general perception, my lord, that general perception has got a silver lining also. Your lordship disposes of matter. If it- Yes.
Lordship. That is your lordship to show that your lordship. No, your lordship. That 276 is your lordship. Page 276, your lordship will find that the materials they have furnished to me, your lordship, that I have shown you. What they have said that lordship, that the lost. By comparing with what he has, the deputy commissioner has mentioned in his paragraph 6 of his affidavit, corresponding to your lordship, those methods. And also, your lordship, one aspect I have pointed out, your lordship, so far as status of some cases, your lordship, I have made a specific amendment in my brief petition. Affect that in some of the cases, Your Lordship, there is a final report already been furnished by the investigating agency. Lordship, that was there, Your Lordship. Yeah. In page 32, Your Lordship, you have made such statement.
That is the document. Like, uh, hmm. People-
Lordship, that Your Lordship, that is not with me, Your Lordship. I have all, the 56, these are the cases they have relied on, Your Lord. First of all, Your Lordship, so far as Lordship. Lordship, to the knowledge of the petitioner, that's what. But I don't have the dates, I don't have the dates. Lord,
Okay.
Lordship, then Your Lordship, it will be different. That, but that just I have made a mention to. And in fact, so far as these cases are concerned, Your Lordship, except 3 cases, Your Lordship, Nagaon, 2 Nagaon and 1 CID. Rest of the, so far as the other cases are concerned, no documents have been furnished to me. Okay.
Or as far as this allegation of non-supply of the documents on which Reliance was placed, my lord, in the affidavit that was filed on behalf of Restaurant number 4, paragraph, sorry, page 164 to 246 are the documents which were supplied. These are the documents which have been supplied. 164 to 246, my lord, in the affidavit filed by Restaurant number 4. Hmm. 246, my lord. 6. Okay. Wait it here. My submission will be the documents, the materials on which reliance is placed to arrive at this satisfaction for passing this detention order. All those documents were supplied according to us. And these are the documents which we are saying that we have supplied him, and the rest, the 13 things on which reliance was not placed to arrive at the satisfaction, those, even if not supplied, will not cause any prejudice to it. This is my submission with regard to this allegation.
He was there in another copy. Lordship, I understand. Lordship, he has no problem. Lordship, fix it for a convenience of lot. Lordship, I'll, okay.
And the another allegation in the writ petition is that in the detention order, there is a reference of an order which was passed under section 3, subsection 3 of the National Security Act. Wrong date was given, wrong number was given. Regarding that matter, on the last occasion itself, I made my submission saying that an order exists, name and a number is different, date is different, and subsequently we have rectified that order. So that has not caused any prejudice to him because power exists, notification exists under section 3, subsection 3. Actual notification under section 3, subsection 3 is notification of 28th of February 2025, but it was somehow wrongly mentioned as 14th of October 2023. Madam. So that has not caused any prejudice whatsoever. That your lordship will find. In the writ petition also they have mentioned, my page 92. Page 92, my 92. In the corrigendum, lordship will find in the second paragraph, we have mentioned the notification which was mentioned in the detention order. And in the third paragraph, we have mentioned what is the actual date of the notification and the number. And this this is with regard to the conferment of power. Yes. Otherwise, normally it is the state, but other officers, if empowered under this section, can also exercise this power of passing the detention order. That is with regard to that one. Regarding another submission, my lord, that by the detention order, the detainee was informed about his right to make representation against the detention order to the state government and to the advisory board, but not to the detaining authority and the central government. Regarding that one, I rely on the 2-3 paragraphs of the judgment of Kamaleshwar Ishwar Das Patel. Because, my lord, so far as the NSA is concerned, in the COFE POSA, my lord, the question of revocation of the detention order by the detaining authority is there. But in the NSA, my lord, it is the appropriate government. There is a difference, and that has been discussed in that judgment. I'll come to that. And as far as the central government is concerned, my lord, subsequently he has informed and he has submitted his representation. And it's for the central government to say what has ultimately happened. They will let this honorable court know, my lord. Then, my lord. In fact, on the last occasion, I made this submission. I'm again repeating, my lord. As far as the allegation that there is a non-application of mind to the relevant facts and the detention order is based on irrelevant facts, grounds are vague, non-existent, irrelevant, incidents referred are not proximate and based on incidents spanning over a period of 7 years. Statement of petitioner has not resulted in untoward incident, etc. Regarding this matter, my submission will be, Lordship may just have a look at page 60 and 61 of the writ petition, matter. Page 60 of the writ petition. 60. But there are three cases referred. One is Nagaon PS case number 340, Nagaon PS case under section so of the BNS. Second is Nagaon PS case number so under section so. And the third one is CID PS case number 5 of 2020 under section. In all the three cases, my lord, Lordship will find that basically the allegations and the allegations are that there is imputation and assertions prejudicial to the national integration. And case was registered in the first one under section 197(1), 1133, then 362, which speaks about intentional insult, intent to provoke breach of peace, then 353 of IPC statements conducting to public mischief, then 153A, imputation assertions to national integration, then, my lord, sedition, then 295A, deliberate and malicious act insulting religion. Then in the third one, my lord, in the CIT PS case again, case is registered under 120B, 153A, 1A, and then important is 153A, 1B, which again speaks about promoting enmity prejudicial to harmony between religion. Then 505 statements conducting to public mischief. Section 505. So, my lord, my submission is, my lord, a perusal of these cases registered and the provisions of law under which the cases registered, and the Lordship will find that in all the cases there are allegations of public mischief, acts prejudicial to national integration, insulting religion, breach of peace, acts prejudicial to harmony between religions. Then proximity is apparent because social media platform is replete with comments provoked by his statement. And what has been written in the social media platforms, that those documents we have already supplied to you. Regarding the allegation that there is no satisfaction recorded by detaining authority in the detention order, and my submission is, if your Lordship refers to page 47 of the writ petition, the detention order, your Lordship will find that detention order clearly records that based on materials placed, he is satisfied that the detainee is likely to continue to engage in activities prejudicial to the interest of the state, etc. Which one, my lord? This one is in response to the allegation that no satisfaction recorded by detaining authority in the detention order. Okay. And my lord, your lordship already, lordships have the dates. The detention order was issued on 14th of May 2025. Then grounds of detention were furnished on 16/5 within time, my lord. 16/5/2025. Then he submitted his representation on 22nd or 23rd of May 2025. The approval under section 3(4) of the NSA, which has to be valid within 12 days, my lord. My lord. Which one, my lord? Grounds. My lord, grounds,
That was not. My
that
submission
point he has not taken.
entire your lordship documents has not been furnished.
No, but this point was not raised, that it was not, grounds were furnished within time, madam.
That is furnished within time. There is no, I have not raised that.
Now, and so far as approval under section 3 subsection 4 is concerned, my lord, that has to be within 12 days, and it was done within 12 days on 25th of May 2025. Lord, may I record that? And this approval was communicated to him on 30th of May 2025. Approval of the state, my lord, in terms of section 3 subsection 4, my lord. Representation to the advisory board was forwarded on 4th of June 2025. And in fact, to the government also, it was forwarded on 4th of June 2025. And on 7/6/2025, my lord, he was communicated that he has got a right to make a representation to the central government. And the detention order was confirmed on 3rd of July 2025, my lord. And the government rejected the representation on 25th of June 2025. Oh. Fine. Yes. In this regard, about his right to make a representation to the detaining authority, which was not initially informed, my lord, I'll be relying on the judgment, my lord. I have not separately given any list of dates. The documents, the judgments which my learned friend has relied, from there only I'll. Your lordship take take up the volume 1, ma'am. Page, I'm relying on that judgment of that Kamleshwar Ishwar Das, my lord. Starts from page 107, it starts, my lord. 5 judges concluded. Starts from page 107. I'm taking your lordship straightway to paragraph 44 at page 126. It- 95.4 is this page 51. Paragraph 44, my lord. At page 126. One 26, 126. Right. Turning page 120. Paragraph 44 of that judgment.
Yes, and a second.
In Satpal versus State of Punjab, the order of detention was made by the state government of Punjab under Section 3 of the Copy-Pasa Act, and the detainee had made 2 representations. One was addressed to Joint Secretary Government of Punjab, and the other was endorsed to the central government through the Secretary, Ministry of Finance, Department of Revenue, New Delhi. Both the representations were forwarded by the Superintendent Central Jail to the Joint Secretary, State Government of Punjab, which with an endorsement that one of them be forwarded to the central government. This is important, man. The state government rejected the representation, but there was a delay on the part of the state government in forwarding the representation to the central government. And ultimately, the central government also rejected the state representation, and there was no delay on the part of the central government in considering the representation. This court held that there was no denial of making a representation to the central government, and the delay on the part of the state government in forwarding the representation to the central government by itself was not sufficient to invalidate the order of detention. Satpal was therefore not a case of non-consideration of the representation by one of the authorities who was required to consider the said representation. In Rajkishore Prasad versus State of Bihar, the order of detention was made by the district magistrate under Section 3, subsection 2 of the National Security Act. The detainee made a representation to the detaining authority, district magistrate, but in the meantime, the case of the detainee was referred to the advisory board and the representation was rejected by the state government after the matter had been considered by the advisory board. The court, while upholding the contention, urged on behalf of the detainee that the constitutionally speaking, a duty is cast on the detaining authority to consider the representation, has referred to Section 8, subsection 1 of the National Security Act, which provides for making a representation against the order, not to the detaining authority, but to the appropriate government, and has observed that this was done presumably to provide an effective check by the appropriate government on the exercise of power by subordinate officers like the district magistrate or the commissioner of police. It was held that if the appropriate government has considered the representation of the detainee, it cannot be said that there is contravention of Article 22, Clause 5, or there is failure to consider the representation by the detaining authority. Similar to our case matter. The detention in Santosh Anand, decision in Santosh Anand was noticed and it was distinguished on the ground that under the National Security Act, there is a specific provision in Section 8 which requires that the detaining authority shall afford the earliest opportunity to make a representation against the order, not to the detaining authority, but to the appropriate government. Because in the COFE POSA, my lord, it is the detaining authority. But in the NSA, it is the appropriate government. The decision in Satpal and Rajkishore Prasad, on which the High Court has placed reliance, do not therefore detract from the law laid down in Santosh Anand. Having found that the representation of the person detained was not considered by the officer making the order of detention, the High Court was in error in holding that the state failure on the part of the detaining authority to consider and decide the representation is not fatal to the order of detention. We are therefore unable to uphold the answer given by the full bench to question number 3, and in our view, the said question should be answered in the affirmative. On that basis, it is to be held that since there was a denial of the constitutional safeguard provided to the detainee under Article 22, Clause 5 of the Constitution on account of the failure on the part of the officer who had made the order of detention to independently consider the representation submitted by the detainee against his detention and to take a decision on the state representation, the further detention of the detainee is rendered illegal. So in our case, my lord, if your lordship goes to Section 8 of the National Security Act, lordship will find in National Security Act, NSA. Or may I read Section 8, man? NSA, man. Section 8 speaks about grounds of order of detention to be disclosed to persons affected by the order. When a person is detained in pursuance of a detention order, the authority making the order shall, as soon as may be, but ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing, not later than 10 days from the date of detention, communicate to him the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order to the appropriate government and not to the detaining authority. But in the COFE POSA, my lord, it is the detaining authority. That is why, my lord, in paragraph 45 of this Kamaleshwar Kumar Ishwardas Patel judgment, it is said that if the appropriate government has considered the representation of the detainee, it cannot be said that there is contravention of Article 22, Clause 4, or there is failure to consider the representation by the detaining authority. And in our case, the government has considered and rejected the representation. My lord, in the same paper book with compilation of judgments, I would like to refer to page 73, which is the recent judgment of Amina Begum's case, my lord. Para 34 to 40. This is, my lord, this few paragraphs of this Amina Begum judgment I am reading for the purpose of replying to the point raised that no satisfaction has been arrived at, there is no material, etc. My para 34, my lord, page 73. The issue, if your lordship has got my page 73. Amina Begum. 23.9, 23.9 3. 5.97. 5.87. Your lordships have got page 73, madam. Yeah. Para 34. The issues with the detention order which we need to address are these. First, whether the alleged acts of commission for which the detainee has been kept under detention are prejudicial to public order. And secondly, whether all relevant circumstances were considered or whether extraneous factors weighed in the mind of the detaining authority, leading to the conclusion that the detainee is a habitual offender and for prevention of further crimes by him, he ought to be detained. Incidentally, the issue of whether application of mind is manifest in first ordering detention and then confirming it by continuing such order for a period of 12 months upon rejection of the representation filed on behalf of the detainee by the appellant could also be answered. Needless to observe, we need not examine the second and the incidental issues if the appeal succeeds on the first issue. Addressing the first issue first, it has to be understood as a fundamental imperative as to how this court has distinguished between disturbances relatable to law and order and disturbances caused to public order. Para 37, madam. Para 36. It is tried that breach of law in all cases does not lead to public disorder. In a catena of judgments, this court has in clear terms noted the difference between law and order and public order. We may refer to the decision of the Constitutional Bench of this court in Ram Manohar Lohia versus State of Bihar, where the difference between law and order and public order was lucidly expressed by Honorable Justice Hidayatullah in the following words: public order, if disturbed, must lead to public disorder. Every breach of peace does not lead to public order. When two drunkards quarrel and fight, there is a disorder but not public order. They can be dealt with under the powers to maintain law and order but cannot be detained on the ground that they were disturbing public order. Suppose that the two fighters were of rival communities and one of them tried to raise communal passions. Problem is still one of law and order, but it raises the apprehension of public order. Other examples can be imagined. The contravention of law always affects order, but before it can be said to affect public order, it must affect the community or the public at large. A mere disturbance of law and order leading to disorder is thus not necessarily sufficient for action and defense of India Act, but under the Defense of India Act, but disturbances which subvert the public order are. It will thus appear that just as public order in the rulings of this court earlier cited was said to comprehend disorders of less gravity than those affecting security of state, law and order also comprehends disorders of less gravity than those affecting public order. This is what I was saying on the last lecture. One has to imagine three concentric circles. Law and order represents the largest circle, within which is the next circle representing public order, and smallest circle represents security of state. It is then easy to see that an act may affect law and order but not public order, just as an act may affect public order but not security of the state. For an act to qualify as a disturbance to public order, the specific activity must have an impact on the broader community or the general public, evoking feelings of fear, panic, or insecurity. Not every case of a general disturbance to public tranquility affects the public order, and the decision to be asked, as articulated by Honorable M. Hidayatullah in Arun Ghosh versus State of West Bengal, does it, the offending act, lead to disturbance of the current of the life of the community so as to amount a disturbance of the public order, or does it affect merely an individual leaving the tranquility of the society undisturbed? Then para 39. In Arun Ghosh case, the party petitioning detainee was detained by an order of a district magistrate since he had been indulging in teasing, harassing, and molesting young girls and assaults on individuals of a locality. While holding that the conduct of the petitioning detainee could be reprehensible, it was further held that it, the offending act, does not add up to the situation where it may be said that the community at large was behind being disturbed, or in other words, there was a breach of public order or likelihood of a breach of public order. In the process of quashing the impugned order, Hidayatullah CJ, while referring to the decision in Ram Manohar Lohia, also ruled public order was said to embrace more of the community than law and order. Public order is even tempo of is the even tempo of life of the community, taking the country as a whole or even as a specified locality. Disturbance of public order is to be distinguished from the acts directed against individuals which do not disturb the society to the extent of causing a general disturbance of public tranquility. It is the degree of disturbance and its effect upon the life of the community in a locality which determines whether the disturbance amounts only to breach of law and order. It is always a question of degree of the harm and its effect upon the community. This question has to be faced in every case on facts. There is no formula by which one case can be distinguished from the other. So by reading this, I want to just support my reply that here is a case matter, the kind of comments he has made. I'm not referring to all those comments I have already made in my submission the last 15 minutes about his comments in respect of the Pahalgam attack and the earlier attack, and subsequently there are three minors. In all the three cases, the bottom line is same. He is speaking against the country. He is speaking in favor of a foreign country and on the basis of the religion. So this is really a case where there is a threat to the security of the state ultimately. And the comments which his statement has evoked are very clear that he is trying to divide the people on the religious lines. And that is why there is a satisfaction that he needs to be detained and disturbing public order as well as security of the state. And lastly, one submission I will make on the basis of this page 9 of this paper book, my lord. The first judgment my learned friend has relied on. Page 9, para 28. Para 28 at page 9, my lord. This is the judgment of Jyoti Kitty Joseph versus Union of India, 2025 4 SSC page 476. Page 9, my lord, para 28. And 29. We are not examining the conditions imposed by the magistrate since it was for the detaining authority to look into it and enter into a subjective satisfaction as to whether the same was sufficient to avoid a preventive detention or otherwise insufficient to restrain him from further involvement in similar smuggling activities. The formation of the opinion about detention rests with the government or the officer authorized. Their satisfaction is all that the law speaks of, and the courts are not constituted an appellate authority. Thus, the sufficiency of the grounds cannot be agitated before the court. However, the detention of a person without a trial, merely on the subjective satisfaction of an authority, however high, is a serious matter. It must require the closest scrutiny of the material on which the decision is formed, leaving no room for errors or at least avoidable errors. The very reason that the courts do not consider the reasonableness of the opinion formed or the sufficiency of the material on which it is based indicates the need for the greatest circumspection on the part of those who wield this power over others. Para 29 manner. If there is a consideration, then reasonableness of the consideration would not have been scrutinized by us in judicial review, since we are not sitting in appeal, and the provision for preventive detention provide for such a subjective satisfaction to be left untouched by the courts. However, when there is no such consideration, then we have to intervene. So here in this case, madam, my submission will be the materials based on which the detention order was issued disclose the involvement of the detainee in spreading hatred among communities, causing security threat to the security of the state and the public order. And therefore, my lord, there are sufficient materials to hold and the validity of the detention order. Regarding the ultimate decision taken by the central government, my learned friend appearing from the central government will inform your lordship matter about the what decision they have taken on the representation committee to the central government. They have not made any representation to the central government. They have not made any representation to the central government. That's all.
Regarding myself, the state government has informed the detainee that his right to submit presentation to central government, but he has not submit any representation. On 7/6 to inform.
May I please? I have lessened the burden of my senior friend, your lordship, by compiling these documents.
I'm thankful to you. My lord.
Lordship. Lord. But in these kind of cases, your lordship, we have no option.
My lord.
Recently, your lordship, Honorable Apex Court has observed in a particular case that out of context mentioning of the paragraph.
Ultimately, what was the conclusion?
Lordship, whereas I will be thought, Your Lordship. First of all, Your Lordship, the last point, my learned senior friend has raised, Your Lordship, referring to para 28 of the judgment in Hamida Begum. No, Joy 60, Your Lordship. That is page 9, Your Lordship. Your Lordship will get the answer, Your Lordship, at page 10, para 32, Your Lordship. May I read your Lord, that paragraph? That is only point. Lordship. Lordship, that is the last point, Your Lordship, on the para 28 of the judgment. Joy 50, Your Lordship. Learned senior friend has page 928 relied on by, then page 10, Your Lordship, will find page para 32, Your Lordship. Just what was the ultimately what was completed by the learned honorable apex protocol. Likewise, in the present case, we are not concerned as to whether the conditions imposed by the magistrate would have taken care of the apprehension expressed by the detaining authority of the detainee indulging in further smuggling activities. Then, we are more concerned with the aspect that the detaining authority did not consider the efficacy of the conditions and enter any satisfaction, however subjective it is, as to the conditions not being sufficient to restrain the detainee from the indulging in such activities. That was what ultimately decided by the honorable Apex, that the conditions imposed by the magistrate, whether it is efficacious or not, that has not been considered by the detaining authority. And that is the aspect which I have raised, Your Lord. And secondly, Your Lordship, the so far as this other judgment, Your Lordship, the Kamaleshwar Ishwardas is concerned, Your Lordship will kindly, just for a moment, Your Lordship may kindly take up. Your Lordship may kindly take up 141 of that volume. Otherwise, Your Lordship, I have also submitted a, Your Lordship, written note of submission, Your Lordship, where the paragraphs I have relied on, Your Lordship, the points which I have wrote, Lordship. Lordship, Lordship.
Twenty-third.
Wait a minute. Oh, yeah.